Does PhonePe need to share sensitive information with law enforcement agencies like police department, ED, CBI, etc.? Especially when the case is about online fraud. If you think the answer is yes, then let me reframe this. Who can demand sensitive information from PhonePe? Hello, welcome to MediaNama. In this video, let's talk about a case of a man from Karnataka which is challenging the identity of digital payment companies. So, what is PhonePe? Is it an intermediary as the company claims, or should it be entitled to protect user information as per the Bankers Book Evidence Act of 1891? This case goes back to 2022. In 2022, an user made a payment of 6,150 rupees to a sports betting website using PhonePe. Shortly after making the payment, the user's betting account was blocked and he was unable to withdraw the funds. So he filed a complaint with Karnataka police. And Karnataka police launched an investigation, and as part of the investigation, the police had asked about the merchant account details from PhonePe. So the central issue in this case, where Karnataka High Court had already ordered PhonePe to share merchant data in connection with the investigation, this decision has some serious implications to digital payment platforms as well as law enforcement agencies. For example, who can have access to the financial data of an user, and what about user privacy? Here are some facts. So the transaction was routed through PhonePe using UPI, Unified Payments Interface. When police requested the merchant information, initially PhonePe refused, citing its legal obligations that can that is that entails to maintain the user's confidentiality. Then PhonePe argued that it functions as a system provider under UPI framework and does not operate or control merchant's bank account. So according to PhonePe, its role is limited to facilitating the transaction. The funds are debited from payer's bank and credited to the payee's bank. The company claimed that it does not process or control merchant details in capacity required by the police. Fair enough. That PhonePe filed a petition challenging the police's notice. It based its argument on Bankers Book Evidence Act of, as we discussed, that was passed in 1891, and Payment Settlement Systems Act, which was passed in 2007. Both of these acts impose restrictions on the disclosure of banking and financial information of the user without proper judicial oversight. However, Karnataka High Court rejected its argument. In its ruling, the court emphasized the importance of confidentiality in financial transactions. At the same time, this this right to confidentiality cannot override legitimate investigative process. The judgment referred to Section 91 of CRPC, Code of Criminal Procedure, which gives the law enforcement agencies the authority to demand documents and records that are important for the investigation. Justice M. Nagaprasanna delivered his verdict, noting that confidentiality must coexist with accountability. The court held that once the offense is under investigation, companies like PhonePe cannot deny access to relevant data purely on the grounds of privacy and confidentiality. So, the court did not find PhonePe of guilty of wrongdoing in the transactionary process. The issue was limited to whether PhonePe is legally required to provide merchant information related to the uh, payment that was done to the fraud website. Then the court said that yes, PhonePe is obliged to share the information with the investigative agencies. This ruling carries broad implications on digital payment providers that are operating through India. So it confirms that platforms involved in the UPI ecosystem can be requested uh, to provide the transactional data of users, but it has to be done through the proper judicial process. The decision also provides clarity on the interaction between uh, financial privacy laws and digital payment systems. The Bankers Book Evidence Act was enacted in 1891. So obviously there weren't UPIs, digital payments back then. The judgment effectively places those older laws within the context of today's financial technologies, fintech ecosystem. For the law enforcement agencies, this judgment is very significant because it strengthens the ability of the investigation by accessing the financial data and money trailing to curb the illegal online activities, especially in the areas like online gambling and gaming. From the industry's perspective, this creates a compliance challenge because the digital payment companies must be prepared to share the users' data if law enforcement agencies comes and requests for the financial data of the user. So there is a practical dimension to this as well. If a system providers like PhonePe are considered to have sufficient control and access to the merchant's data, they need to reassess how do they store the data and how are they auditing it and how can they protect this information from data breaches and falling the data into the third party actors. This includes revisiting privacy policies and terms of service that back the payment companies to ensure the user's privacy. At the same time, it is important to highlight that this ruling does not open the doors for arbitrary data access by enforcement agencies because the law enforcement agencies must follow the legal judicial process. Section 91 of CRPC, Criminal Procedure Code, requires formal summons, and the court has to make clear that any data request must be specific and justified as part of active investigation. This distinction matters because it preserves the legal barrier between data requests by the enforcement agencies and those that serve legitimate investigative purpose. It also provides a roadmap on how companies can respond to such requests without compromising the trust of the user. So, so at the end, the case reaffirms a very key point in digital ecosystem. In the digital economy, technological neutrality does not equal to legal immunity. If a company plays a key role in facilitating financial transaction, it may be subject to scrutiny when the transaction becomes a part of the criminal investigation. So, Karnataka High Court's ruling requires PhonePe to share merchant information related to the online fraud. It also rejects the argument that the system providers under a UPI framework can claim absolute confidentiality, and it also clarifies that privacy protections do not override and should not override the lawful investigative process according to Section 91 of CRPC. This case sets a precedent that can shape how data sharing obligations are to be interpreted between law enforcement agencies and fintech sector. If you want to understand how the laws are adapting to the technology and what it means to the end user and app developers, cases like this are very valuable, and you can read more about such cases on our website medianama.com. Thank you for watching us.